people, welcome back to the channel. Today we are talking about something major, something that is shaking immigrant families across the globe, especially parents who work so hard for the green card. Trump's new immigration policy has dropped and is targeting one of the most sacred things about America: birthright citizenship. Yes, the idea that if your baby is born in the US, they are automatically American. But what happens if you are a green card holder? What does this mean for your kids born in the US? What does it mean for you as a parent? Let's break it down. The shocking new rule. So here's the gist. On January 20th, 2025, President Trump, just days into his return to office, signed an executive order that redefines how US citizenship is granted to children born in the United States. It basically says a child born in the US is not a US citizen unless at least one parent is a US citizen or lawful permanent resident, that is green card holder, at the time of the birth. Let that sink in. Gone are the days when being born in the US automatically means you'll be American regardless of your parents' immigration status. And here is the scary part. It's already taking effect for babies born after February 19th, 2025. Now you might be thinking, but I'm a green card holder, my child should be fine, right? Well, maybe, but here is where it gets tricky. One, if both parents are on temporary visa like H-1B, F-1 visiting visa, their baby is not a citizen under the rule. The second thing is, if one parent is a green card holder but the child is born outside the US, that's another layer of complication. The third is that, and even if you are a green card holder but living abroad temporarily, there is now legal confusion around whether your child qualifies, especially if you've been out of the country for more than 6 months. Let's say you are a Nigerian couple living in Canada, you hold US green card but temporarily move to work. You travel to the US to give birth under the old rule. Your child equals US citizen. Under Trump's new rule, that might not be enough anymore. So let me bring this home with a real world example. Okay, Sarah and David are Nigerian immigrants. David works in IT and got a green card through his company. They moved to the US in 2019, had a son in Texas in 2021, and then moved to Dubai in 2024 for a job opportunity. They plan to return to the US for their second baby. Then Trump's order happened. Now they are stuck in limbo. Sarah is pregnant, but their lawyer says their unborn baby might not be recognized as a citizen, even if born in the US, because they've been out of the country too long to prove permanent residency. It is emotionally draining, right? Their baby's future is uncertain, and it's not just about a passport, it's about school fees, health insurance, inheritance, and the right to return to America someday. Now let's get into the law. The 14th Amendment to the US Constitution says all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States. This clause was originally written to ensure that freed slaves and their descendants were US citizens. But over the years, it became the backbone of birthright citizenship, what Americans call jus soli, right of the soil. Trump's new executive order challenged this. He claimed that, subject to the jurisdiction, should only apply to parents who already have citizenship or green card status at the time of the child's birth. Lawyers and civil rights groups say it's unconstitutional. Court battles have already begun. Some courts have even issued temporary blocks. but with a conservative Learning Supreme Court, anything is possible. This is not just about documents or legal theory. This is about real families, real kids. Let's break it down. If your child is already born before February 19, 2025, they are still safe under the old law for now. Yeah, for now. If your child is born after that date and neither parent is a US citizen or active green card holder residing in the US, your baby might not be eligible for citizenship. If you are abroad temporarily, your green card might not be enough unless you can prove continuous ties to the US. Now imagine the chaos. Kids denied passports, denied entry back into the US, families split across borders, babies becoming stateless in some cases. It's not just harsh, it's traumatizing. So what should you do if you are affected or worried? Number one is for you to talk to an immigration lawyer ASAP, as soon as possible. Many are offering free consultations because this policy has shaken so many families. The second thing you can do is review your travel plans. If you're a green card holder living abroad, make sure your time outside the US has not invalidated your residency. The third thing you can do is keep your legal documents up to date. That means passport, birth certificate, proof of US ties like taxes, properties, school enrollment, and so on. The fourth thing you can do is follow reliable news outlets and advocacy groups. This situation is changing rapidly. There are lawsuits, court blogs, and appeal in motion. The fifth thing you can do is share your story. The more stories like Sarah's get out there, the more pressure builds to challenge this rule politically and legally. This is more than just a policy change. This is a human issue. It is about identity. It is about families who trusted the system and now feel betrayed. And it's about what kind of country America wants to be. Birthright citizenship has been a promise. One that said you belong here if you were born here. If that promise disappears, what's next? Let me know in the comments if this policy affects you or someone you know. Don't forget to like, subscribe, and share this video. This story needs to be heard. Okay? Stay informed, stay empowered, and above all, stay hopeful. Thanks for watching. I will see you in the next one.